On jurisdiction, the second respondent submits that the Supreme Court has jurisdiction to clarify its judgment or orders as set out in Section 21(4) of the Supreme Court Act. He states that the scope of the power under that section was considered in Nick Kiptoarap Koril Salat versus the IEBC and 7 others, 2014 EKLR, while its purpose was identified in Frederick Otieno Outa versus Jared Odoyo Okello and 3 others, the Outa case. To further support his case, the second respondent relies upon the decision of the Supreme Court of Appeal of South Africa in the case of Butters versus Mancora, to the effect that a court may clarify its judgment or order if, on proper interpretation, the meaning remains uncertain and it seeks to give effect to its true intention. He also cites the decision of the Supreme Court of British Columbia, where it was stated that the inherent jurisdiction of the court can be invoked to clarify an ambiguity in the court's ruling where the meaning and intention of the court is not clearly expressed in the judgment or in the order. Further, the second respondent refers to the decision of the Superior Court of Justice in Ontario, Canada, where it was stated that clarification is a less contentious matter and it may be given where the original judgment was so expressed as to lead to uncertainty and confusion or contains a latent ambiguity. He also refers to the decision of our Court of Appeal in the Standard Chartered Financial Services and another case versus Manchester Outfitters, where the jurisdiction of a final court to clarify its judgment was considered. The second respondent also refers to the East African Court of Appeal decision in Mauji on the same point. On the issue of clarification being sought, the second respondent submits that there are matters requiring clarification in the court's judgment, and he has identified areas likely to raise implementation challenges and therefore requiring clarification. He also compares the minor KI decision and this court's decision, specifically at pages 36 and 38 of the minor KI decision and paragraphs 290, 292, and 294 of the Supreme Court judgment. He submits that it is his understanding in that context that the Supreme Court expected him to compare results in Forms 34A as against the tallies in Forms 34B, and that it was not open to him, as stated at paragraph 294 of the judgment, to ignore any discrepancies arising from such comparison. It is in his further submission that for purposes of ensuring the implementation of the true intention of the court, it is necessary for this court to fill the omission occasioned by the absence of a direction as to what the second respondent is required to do in the event of a discrepancy. In